Welcome to the Lawrence University Career Center podcast. I'm Ty Collins, and today we welcome the Honorable Peter Navis to the podcast, a Lawrence University grad from the class of 2003. He served as a circuit court commissioner in Walworth County, Wisconsin. Majoring in government with minors in philosophy and linguistics, he attended Hamline University of Law, earning his JD in 2007. After several years working as an attorney in private practice, he moved to public service, serving about 10 years as an assistant corporation counsel in Dodge and Walworth counties before being appointed to the position of judicial court commissioner for Walworth County. Today, we discuss how his time at Lawrence shaped his thinking, what he's learned through public service, and how his values guided him in seeking justice and truth from the bench. Commissioner Navis, thanks for joining us.
I'm happy to be here. I'm looking forward to talking over with my experience at Lawrence and my career, and hopefully it'll be helpful to those listening.
It's been 20 years since your time at Lawrence. How has your time at LU influenced your career to date?
One of the things that I knew going into Lawrence was I knew I wanted to be a lawyer, but I didn't really know why I wanted to be a lawyer. And that's really where Lawrence helped me. There wasn't a single moment in my time at Lawrence. It was kind of a slow, steady accumulation of experiences that I had. And it started right with first year studies. Some of the works that we studied was Plato's Republic, Akira Kurosawa's Rashomon, and continuing all the way through until my senior year, where I had an independent study in language in the law. The commonality that I had with all these experiences was that I was exposed to different viewpoints, whether that was my classmates' personal experiences or the different academic backgrounds of the professors that I had. All of these worked together to help me realize why I wanted to be a lawyer. And it really was because I had an insatiable curiosity for the law. And that has served me very well in my 20 years after Lawrence.
How did your education here contribute to your ability to navigate complex legal issues specifically, as well as some of the ethical dilemmas you faced in your career?
So the key to complex legal issues and ethical dilemmas is that there's more than one side to it. If there's only one side, it wouldn't be complex and it wouldn't be a dilemma. But if you only look at one side of these types of issues, you're going to get an incomplete view and then an incomplete outcome. And so you have to be able to identify and fairly evaluate all the aspects of these types of issues without a preference for an outcome. It's kind of like if you have a complicated knot. If you just look at one part of the knot and start tugging at it, you might get lucky and untie it, but you might also struggle with it and get frustrated. You really have to look at that knot, see where all the different strings are interwoven, and to understand how to unravel it. And liberal arts allows you to look at the big picture. It's not just a single track of study, whether it's political science or chemistry or English or whatever, but really forces you into critical thinking and looking at things from all sorts of perspectives, which helps, I think, avoid any bias that you might have in evaluating complex legal issues or ethical dilemmas.
One of the first questions I ask aspiring law school students is, why do you want to be a lawyer? And I get a variety of responses. What would you say to that question?
I want to share a story of my law school orientation. We had a luncheon that first day, and all of us new students sat at tables, and we each had a professor, law school professor, sitting with us. And before the lunch began, the professor at our table asked each of us, why did you want to go to law school? Why did you want to become a lawyer? And I can still remember the first person saying, because I want to help people. And that professor said, you're not going to make it as a lawyer. And we all kind of shocked because I think we all kind of felt to some degree that we want to help people. And her reasoning was that you can help people in any capacity, in any career. Teachers help people, law enforcement officers help people, lawyers help people, sanitation workers help people. Everybody can help people in their profession. She clarified you have to have a good reason to be a lawyer to make it as a lawyer. And that's, as I said before, I have this insatiable curiosity for the law. And this was the answer that I gave the professor, is that I want to study it. I want to explore how it interacts with life, to discover connections between different aspects within the law, to watch it grow and change and adjust over time, and to discuss it with anyone who wants to discuss it.
Well, your career path has led from the private sector into public service. What inspired you to make that change, to go into the public sector? How do you view the role of public service in the legal profession?
I started in private practice, to be blunt, because that's the job that was offered to me out of law school. It was a great job. I learned a lot from the other lawyers in the law firm I was in. It was including myself, three attorneys and three support staff. I learned a lot from them. I learned how to help clients, how to listen to them, how to advocate for them in the courtroom. These were all things that I didn't learn in law school, but I learned on the job. But I knew that ultimately I would not be fulfilled as a lawyer if I stayed in that position. So I applied for public lawyer positions regularly, whether it was, a prosecutor in the district attorney's office, public defender, city attorney's offices, county positions, state agencies, and eventually I got an opportunity with it's called corporation counsel, which is essentially the civil lawyers for a county. And that's really where I felt my career began to blossom, because I had those opportunities that I wanted to be able to see the connections and interactions in the law and with people in a way that I really couldn't in private practice. In private practice, you represent a client and you have to advocate for that client, and that's a great thing. You're certainly serving those clients. A public lawyer doesn't. A public lawyer does have a client, but it's usually the public at large or the municipality. And so, because of that, you're a little bit removed from that normal attorney-client dynamic that might keep you focused on that and away from the things that interested me. Um, the transition itself, because of my goals, was pretty easy. I had learned a lot about the different types of public lawyer positions that were out there. And so I knew a lot of the requirements or expectations of those positions. And so it fit pretty naturally for me once I started in those positions, or in that first position. The role of a public lawyer, again, regardless of whether it's a prosecutor, public defender, or any other types of positions, is to ensure the vitality of our public institutions. It's important to have good prosecutors. It's important to have good public defenders. It's important to have good attorneys at state agencies that recognize the importance of their institutions and their role within the court system or the broader legal world, because that's kind of where it all is centralized. Most of what is done in the law involves courtrooms or paperwork, whether it's contracts or laws or things like that. And if you don't have good lawyers in the public sector, you're going to have ineffective public institutions.
So I want to drill down a little bit more into the specifics of your job and kind of what you do every day. You're a court commissioner. What is that? And can you give us a behind the scenes look at your day or your week as a commissioner? How do you spend your time? What do you do? How do you direct your energies? Just kind of that snapshot of everything.
In a very broad sense, a court commissioner in Wisconsin is a judicial officer that helps the judges do their job more effectively. And I say that, and I don't mean to suggest that judges aren't able to do that effectively on their own, but the reality is that there's such an overwhelming amount of work in a courthouse that having court commissioners available can help the judges manage those responsibilities. A court commissioner is sometimes called a magistrate in other jurisdictions. The court commissioner is not an elected position like judges are. Rather, we're appointed by the judges to serve, as I said, to assist them. And because we are judicial officers, we do have very broad authority in hearing and deciding cases. However, we do not have the full authority that a judge has. Probably the best example is that judges can do jury trials. Commissioners cannot do jury trials. We cannot sentence defendants after they've been convicted. Again, that's only for a judge. We can't preside over some different kinds of contested trials. For example, a contested divorce case or eviction trials. But by and large, everything else we can be involved in some capacity. Most of the work that we do is reviewable by a judge. If a party thinks I got it wrong, they can ask the judge to hear the case brand new. So that's a very broad picture of it. Every county in Wisconsin can decide whether they want to have court commissioners, and if so, how many. But then the judges of that county determine the authority that that commissioner or commissioners have. In Walworth County, we have two full-time court commissioners. We have a family court commissioner and a judicial court commissioner. I'm the judicial court commissioner. The family court commissioner, as the name kind of implies, hears family court cases. So whether that's divorce proceedings or child support issues, things like that, she hears on a daily basis. My responsibilities are pretty much anything that is not family court related. So I have hearings, criminal hearings, I have small claims hearings, civil hearings, really just about anything other than family. On a day-to-day basis, I'm in court more than half the day for sure, sometimes closer to 6 or even a full 8 hours. Yeah, and the way I have my calendar structured is that each day has a particular type of set of hearings or cases. So Mondays are generally criminal types of hearings. Tuesdays are kind of a mix, a little bit of criminal and a little bit of or juvenile cases. Wednesdays are my most open day, but usually they're still pretty full with more specific individual hearings rather than a large group of hearings. Thursday is my small claims day. Small claims includes cases like homeowner disputes with a contractor or personal injury cases if the amount at issue is not very large. Lost property or stolen property can sometimes be cases that would be on that docket as well. And then Friday is more criminal again. I have other non-court responsibilities. In a way, I'm the law clerk for the judges. So if they have a research issue or they would like me to draft a written order for them, I can prepare that, conduct that work, and then they have the final review and final say. It's going to be their name on the order after all, but they'll sometimes ask me to assist with that. I'm also responsible for overseeing some of the court staff that we have here. I do have a clerk who is with me in all of my court hearings. There's other responsibilities here and there that the judges or the county might assign me kind of on an ad hoc basis that sometimes can be very last minute and sometimes have kind of a longer range for completion.
You have talked about your personal judicial philosophy as transcending labels like originalist and textualist. What does that mean? And can you elaborate on how this perspective guides your decision-making process?
In some of the classes that I took at Lawrence and then also in law school, we learned about these types of labels. And in the academic sense, these labels were intended to mean a particular thing. And broadly speaking, it would describe the process by which a judicial official interprets the law as part of reaching their decision on a case. That's the academic side of it, the intellectual side of it. But in practice, those terms lately have kind of taken on a different meaning. They're almost being used as a shorthand to describe a court official as a conservative or a liberal or a Democrat or a Republican, with the intent then being, or the perception being, that if you're an originalist or if you're an activist or whatever the label might be, then you're outcome focused rather than the process focused. And that leads to or can lead, and perhaps often does lead to a public perception that the court official has already decided a case. That because you're this type of judge or commissioner, you're always going to decide cases like this. And that view really leads to distrust of the judiciary and a view that the judiciary is not fair, it's not impartial. And that's something that I prefer to avoid, that perception. Really, my judicial philosophy is not groundbreaking. It's not original to me. It's what I was taught in law school. And that is that there's a clear process to follow for deciding cases. That is to receive and evaluate the evidence, determine the facts of the case, understand the law that's applicable to that case, and then apply the facts to the law. And I don't mean to say that this is a mechanical process. I have told litigants in my courtroom, spoken with other attorneys about this, that the law is not just simply input data into a computer and get a decision, because at the root of every case is humans, people, and you have to take that into account, certainly. But this is the process that you follow. And when you're in this process, you have to maintain fairness and impartiality throughout it. And the risk of these labels, again, even on the academic viewpoint of it, that it describes the process for evaluating or interpreting law, can at times risk at least the public perception of a lack of fairness and impartiality. The law is what it is. It has developed and grown over time, and we can access that law, whether it's in the statutes or in cases, to see what it is. And then by doing that, by following this process and being fair and impartial, then we can present a decision that is fair, that the public and the parties involved in a particular case can understand and respect.
Well, you mentioned kind of the issue of trust in the judiciary, and we are in an era where, trust in nearly all institutions is declining, including in the courts. Do you think the judiciary does need to regain and strengthen the public's confidence? And if so, how does it do it?
So I'll say this, I am not going to be the source of the solution in the broad sense of it. It's an issue that has come up across the country and within our own state. And it's going to take every court official in the country and in the state of Wisconsin to be vigilant about these issues. The law is what it is. The facts of the case are what the facts of the case are. That doesn't mean that every outcome is predetermined or every case is predetermined. But the parties in the case and the public that is observing the case, again, it doesn't matter if it's a hearing in my courtroom in Walworth County, Wisconsin, or if it's a decision of the United States Supreme Court, people are watching it. And they need to know that the court isn't predetermining these cases, that they don't have a bias that skews the decision. Like I talked about earlier, that it's not an outcome focused perspective, but it's the process focused. Being open, being transparent about the process, about how a decision is made, goes a long way towards that. One example I can use from my own courtroom was one of the types of hearings that I have pretty regularly are harassment injunctions, which is, in very simple terms, one person is asking the court to order that another person can't have contact with them because of actions or threats that this other person has made against them. It can come up in a lot of different contexts, but a fairly common one, and the one for this example, is a romantic relationship that ended. It may end for a variety of reasons, but it has ended. In this particular case, during the hearing, the parties started talking over each other. It was becoming very emotional. And so I had to stop them and then just take a moment. And what the issue was both of these parties felt that no one was going to listen to them. That when they had called law enforcement or they had talked to friends or family, that people took up sides or they downplayed the seriousness of the issues between these two people. And so they felt that coming to court was going to be just more of the same. And so that's where their frustration was. And so before continuing with the hearing, I explained to them in detail how the process works. I explain to them that they're each going to get an opportunity to share their side of the story, that they will each be treated with respect by me, and that they are to treat each other with respect. In other words, let them talk even if you don't like what they're talking about or what they're saying. And then I told them when you both have shared your story, you're provided your evidence, I'll make my decision. I'm going to explain to you how I reached that decision. The hearing proceeded fine after that. They were respectful. They waited their turn. I ended up granting the injunction, prohibiting the other party from having any contact whatsoever with with the person that was asking for the order. And when we were done, the losing party thanked me, not because they lost, but because I had actually listened to them, that I showed them respect, that I demonstrated that I cared about these issues between the two of them, that they hadn't seen from anybody else before. That's the kind of thing that the courts need to do on a regular basis. And it's not easy. As I talked about earlier, we're very busy. We're going from one hearing to the next, often without much of a break in between. And so there's a pressure to move as quick as you can. What angers me is I had a professor in law school who said, no one comes to court when things are going good.
Yeah.
It's always when there's something that's wrong. And that's true whether it's a criminal case or a family dispute or small claims or whatever. There, at the root of it, there's a problem that needs to be addressed. And when there's those problems, there's emotions. And the court needs to take the time to recognize that part of the case. Now, we can't be swayed by emotions in reaching our decisions, but we need to remember that we're making decisions that affect people's lives. And that carries a responsibility, I think, that we need to make sure that they are understanding our process so they can respect the outcome.
You've said that fairness, responsibility, and integrity are central to your courtroom. Can you share an example where these values directly impacted the outcome of a case or the courtroom environment?
Right. So the story I just shared certainly touches on that. And this idea of fairness, responsibility, and integrity predates that hearing by quite a while. I have had the opportunity to observe lots of judges in my career, many of whom are very, very good judges. And one of the common features of those judges that are respected and trusted by attorneys and parties in the public is that they treat people with fairness, that there's an expectation of responsibility, and that the judge has integrity. So for me, this idea of fairness means that everyone who comes into my courtroom is going to be treated impartially and without discrimination. Again, that applies to the parties of the case, witnesses, victims, attorneys, members of the public. It's well known that everyone is equal before the law, and because of that, they need to be treated fairly and with respect. Responsibility for me means that everyone who comes into the courtroom, and this applies to me too, does what they're supposed to do and accepts the consequences of their actions. Attorneys have responsibilities to be prepared and to advocate for their clients. Witnesses have a responsibility to tell the truth. And members of the public have a responsibility to be respectful to the court and to others in the courtroom. And I have that responsibility to decide cases based upon the facts and law of the case, not how I feel about the case or the emotions of one party or the other. And integrity means that I say what I mean and I mean what I say, that people can count on the way I approach things, that they know they can trust me. Trust is vital to our court system, and to me, that's built on integrity. It is not easy to put these into practice. There's a lot of push and pull, and the volume of cases that we have to decide sometimes pressures us into moving quickly through hearings and sidestepping uh, maybe a fairness issue. But it's important to be vigilant on that because it's the right way to do, or it's the right way to handle my court hearings.
Well, we have time for one last question. So, talking about advice you'd offer current students considering a career in law or public service, what would you tell them?
I got a couple of pieces of advice.
Okay.
The first and foremost is to know why you want to be a lawyer. I said this a few times, but a career in the law is incredibly rewarding. I do not regret for a moment my decision to pursue a career in the law, but it can be very challenging. It can lead to fatigue and self-doubt sometimes. And I turn back to my reason many times. Now, my reason is going to be different than other people's reasons. I'm not saying that in order to be a good lawyer, you have to be like me and have a curiosity for the law. For some people, it's to protect the rights of people that are unable to protect their own rights. For some people, it's to see that justice is done. For some, it's they love writing complex documents. So they want to draft contracts for a career. That's great. But you need to know what that reason is so that when you have these challenges and doubts and fatigue, you don't fall away from the law. I know many that went to my law school that weren't there for the right reasons, or at least not their right reasons, and changed careers. Now they're happier now, which is good. But you need to know why you're getting involved in the law. Kind of related to that is don't be swayed by others' expectations, like what law school to go to, what area of the law to pursue, because you're not, if they're not your expectations or your view on it, again, when you face these challenges, you're going to leave the law and find something that is the right fit. So find your fit, find the law school that fits your personality and your experiences and what your goals are. Find an area of the law that fulfills your interests again. And the last thing I'm going to say is ask questions. I ask questions all the time. I did when I was at Lawrence. I did when I was in law school. I do in my career. One of the fun things about lawyers is we love to talk about ourselves, like I am today. We like to share our experiences with others, not because we're self-aggrandizing, although maybe some are, but we want other people to find a career in the law to be as rewarding for them as it is for us. And the best way to do that is to ask those questions, find out what it's like to be a contract lawyer or what it's like to be a prosecutor, what law school is like, all these types of issues. Ask the questions so that you can find your right fit.
Walworth County Circuit Court Commissioner Peter Navis from the Lawrence class of 2003. Thank you for joining us on the Career Center podcast.
It was a pleasure to talk with you today, Ty. Thank you.